Next up, we have the matter of TE versus VE. I am so sorry to my friends who have purchased the course pack. I'm going to make you page a little bit. You can find it in the bundle on page 226 and in the summary on page 10. The reason for that is I prepared the bundle chronologically as the judgments came in, and later on I reordered everything into various categories just to make the presentation run a bit smoother. So TE versus VE 2024 ZAGP JHC 91. The judgment landed right in the beginning of February, 2 February 2024, and the judge von Ludwig AJ. Very interesting judgment, a very nice Rule 43 judgment to read, in that it is crisp, it is clear, and it goes through the necessary information quite quickly and concisely. What is an issue in this matter? It was a Rule 43 interim care and maintenance. There was a request for a contribution to cost, and then also by consent bonding therapy was ordered in respect of the minor children, obviously within the capabilities of the Rule 43 court to do in terms of the definition of care. So what happened? The applicant approached the Rule 43 in respect of interim care and maintenance, and also sought a contribution to costs. Early on in the judgment, the court commends the parties for agreeing on an assessment process, which is something that we're seeing quite a lot in Rule 43s these days, given that they happen quite early in the proceedings, and that it is almost invariably necessary for some sort of assessment process if parental responsibilities and rights are in issue in the divorce. The key word in this judgment is balance. The court sought to balance the interim maintenance to maintain the children and the parties' lifestyle without burdening the husband in this case, who was the sole income earner. And the court, I think, in this case had a very invidious position. And the judge says in the beginning, that you have to really strike a balance between what is reasonable, what do you need to live, and how much money is there in the pot. The reality is, obviously, as all of us know, that in the context of divorce, especially if there is one breadwinner who now needs to support two properties or two households, it does become a bit of a financial tightrope that needs to be navigated. Then what happened here and what was considered? Obviously, the court restated the purpose of Rule 43. The court looked at the importance of accurate financial disclosure and the court's challenges in adjudicating financial aspects in divorce proceedings. Obviously, in this case, fortunately, being in Gauteng, in Johannesburg, the court would have been privy to the financial disclosure forms of the parties. And then from paragraphs 5 to 11, there is an interesting discussion on the court's role in creating this balancing act. So there was a Rule 43 order granted in terms of some of the aspects. For example, the assessment mechanisms. A lot of this was done by consent with a little bit of intervention by the court just to change wording here and there, which is evident from the judgment. And then the judge made a order in terms of Rule 43, in terms of interim maintenance, and for a contribution to cost, which the court kind of said, well, neither party is going to really be happy with this. I've put the one quote up on the slides for you, but I will share both of them with you. The one is paragraph 5. The court is then tasked to determine what is best for the children and how whatever money is determined to be available or at worst accessible for interim purposes can be apportioned in a way that ensures all role players are able to live and continue through the litigation, or hopefully towards a resolution, in the best possible way for their particular set of circumstances. Very interesting that the court makes it quite clear that this is not an ideal set of circumstances. You have to do what you can with what you've got. Then further on, paragraph 11, reads as follows: as such, the court has arrived at the figures which are ordered below, far from what the respondent sought, but almost double what the applicant offered. This is a result which will leave both parties unhappy. But respondent and the children must eat, get about, have toiletries and other usuals, and the home must run. Applicant has been able to access interim funds from somewhere and must continue to do so in the short term. It is up to the parties to ensure that the litigation proceeds expeditiously so that this is not longer than it needs to be. And whilst parties should stay out of court if at all possible, there is always a remedy if the circumstances of either should change materially. And that obviously referring to Rule 43.6 mechanism based on a change in circumstances. Very interesting judgment. The exact order, I'm quickly going to pull it up on my side. If I can just get Adobe to cooperate with me, I will share with you exactly what the order was. It was quite a substantial contribution to costs. I think it was 100,000 Rand or something to that effect. Let me quickly get my bundle open. And of course, Adobe is not working with me. Let's scroll down at the speed of white lightning, and then hopefully I can share with you. So obviously there was the order with regards to primary residence and contact. Then there was the order with regards to bonding therapy. So order 1, full PRR. There was an assessment. Then there was orders regarding the parties making themselves available, who pays for it, what will happen pending this, and then essentially the Rule 43 financial order was to the tune of a few thousand rands in terms of contributions, and then contribution to legal costs of, I grossly underestimated, 452,000 Rand payable by installments to the respondent's legal team. Now, very, very interesting judgment, evidencing the balancing act that has to be struck by judges in Rule 43 matters, and the question, obviously, how one can make the judges' lives a bit easier. I think, obviously, the financial disclosure affidavit goes a long way towards doing so, in that it is standardized, it is under oath, and it is fairly concise.